Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the street that are mass shootings we don't even hear about.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
Because they like the outcome of the policy, the banning of a piece of plastic.
California's high-capacity mag prohibition. In a split decision that may be appealed to the U.S. Supreme Court, the 9th U.S. Circuit Court of Appeals overruled the judgment made by 2 of its justices and upheld California's prohibition on high-capacity mags. The court ruled 7-4 that the law simply restricts the size of mags that can be used with rifles, not any specific weapons. The majority stated the limitation interferes only minimally with the core right of self-defense, as there is no evidence that anyone has ever been able to defend his or her home and family due to the lack of a large capacity mag. And the limitation saves lives. After 2 of 3 justices on a narrower 9th Circuit panel last year found that the state's limit on mags storing more than 10 bullets violates the U.S. Constitution's protection of the right to bear weapons, the 11-member panel of the San Francisco-based court took action. Organizations that support gun rights want to file an appeal with the U.S. Supreme Court, a high court that leans further to the right due to appointments made by the former President Donald Trump has been the target of their efforts to get issues involving firearms heard there. Large capacity mags are commonly used by Americans for self-defense, according to 9th Circuit Judge Patrick Bumatai, who was selected by Trump. Indeed, he stated, these mags are standard on the most popular firearms sold today and are lawfully owned by millions of people across the nation. Half of all firearms mags currently in use in this country would have to be seized if California's law were to be implemented nationwide. 2 additional justices concurred in his dissent, and a 4th judge also issued a dissenting opinion. Which legal criteria should be applied to decide the result was a key factor in the majority judgment, and the 9th Circuit majority opted for the stricter standard. It concluded that intermediate scrutiny was appropriate since the restriction only slightly burdened the fundamental right to keep and bear weapons guaranteed by the Second Amendment.
Because they like the outcome of the policy, the banning of a piece of plastic.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
Obviously they're gone, but will be an inspiration for us to do more. I'm not going to sign this bill into law.
Circuit decision in U.S. v. Rahimi is worth highlighting. As others have noted, the panel struck down a federal statute.
In its upcoming ruling on a New York concealed weapons regulation, the Supreme Court is expected to choose a lower legal bar for Second Amendment issues. This is what gun rights advocates are hoping will happen, although this particular 11-judge panel had the necessary votes to overturn the lower court's ruling. We are unhappy, but not at all surprised by it. But the battle is far from finished, said Chuck Mitchell, President and General Counsel of the California Rifle and Pistol Association. On the 9th Circuit panel, 7 judges were chosen by Democratic presidents. He said that the panel was bitterly divided and that the Supreme Court should consider the case to clarify how a Second Amendment challenge should be evaluated. According to legal experts, the New York case, which is still pending, is a more likely candidate for such a verdict. John Donahue, a professor at Stanford Law School and an expert witness for the state, adding that the High Court typically intervenes to resolve contradictory appellate court judgments, which don't exist in this instance. Donahue remarked, usually the cases where the Supreme Court has intervened are where you've taken guns away from people. The ability to fire more than 10 shots without reloading is the only item being removed in this situation. With the political court, he and Berkeley law professor Frank Zimring, who was not engaged in the case, opined that anything is possible. Limiting mag capacity, however, is marching pretty far from the core meaning of individual self-defense. According to Zimring, Rob Bonta, the Attorney General of California, and proponents of gun control welcomed the decision as a victory for public safety in California. He referred to the ban on high-capacity mags as a sensible solution to the epidemic of gun violence, which includes devastating mass slayings. In the last 50 years, every mass slaying that resulted in 20 or more fatalities, as well as around 3/4 of those that resulted in 10 or more fatalities, according to the majority of the court, used high-capacity mags. According to the court, mass slayings with high-capacity mags resulted in more than twice as many fatalities or injuries as those involving mags with less firepower. The Brady Gun Control Advocacy's Group Chief Counsel, Jonathan Lowy, stated that the court's majority correctly held that the Constitution, properly understood, does not prevent Americans from enacting the gun laws they want and need to protect their families and communities, and it does not entitle people to weapons of war. A state statute that forbade the purchase or sale of large-capacity mags since 2000 was deemed unlawful by U.S. District Judge Roger Benitez of San Diego in 2014. The regulation allowed people who already owned the publications to keep them, but prohibited new sales or imports. A voter-approved measures that would have made it illegal for gun owners to own mags holding more than 10 bullets was also blocked by Benitez. It had the practical effect of forcing those who already had firearms with such mags to surrender them. Before Benitez decided to postpone his decision pending an appeal, gun advocates calculated that over 1 million high-capacity mags may have legally streamed into California over a 1-week interval. The stay was maintained by the 3-judge Ninth Circuit panel, which upheld Benitez's decision, in addition to having an impact on high-capacity mag laws in California and other states. The decision also removes a barrier of their ongoing litigation involving the state's assault weapon ban. Leading proponents of gun control, Everytown for Gun Safety, claimed that the state officials' appeal of Benitez's decision to overturn California's assault weapon limitations this year was on pause, while the Ninth Circuit evaluated the ban on high-capacity mags. U.S. Supreme Court revisits gun restrictions. Following the High Court's significant decision in a gun case, the U.S. Supreme Court overturned the decision in a San Diego case that upheld California's restriction on firearm mags that carry more than 10 bullets and sent it back to a lower court for reconsideration. The Supreme Court also mandated that other gun prohibitions in Hawaii, New Jersey, and Maryland be given a similar second look. The Supreme Court ordered lower courts to re-evaluate a number of cases that had been waiting for the top court's decision in light of the decision, which stated that Americans have a right to carry a pistol outside the home, a Maryland assault weapons prohibition, and a Hawaii law that places restriction on who is allowed to carry a gun outside the home are two examples of such cases. The judges overturned a New York statute that demanded proper cause or a stated need to carry a gun from anybody wishing to do so in public. The decision called into question similar laws that are present in 6 states. In the New York case, the conservative majority of the court provided new instructions to lower courts regarding how to assess gun restrictions. The appeals court's prior usage of a 2-step procedure was rejected by the justices as having one step too many. They argued that judges evaluating current gun control laws should only consider whether they are consistent with the text and historical understanding of the Second Amendment. Other gun cases being returned to law courts will allow them to use this new advice. The 9th U.S. Circuit Court of Appeals was directed by the Supreme Court to review its 7-4 decision from a year ago that upheld California's restriction on mags that may store more than 10 bullets. The order lengthens the judicial process for the case, which is situated in San Diego. Instead of the 15-round restrictions in existence since 1990,
inventing the pistol stabilizing brace to help his friend, a disabled combat veteran, at the shooting range.
You gave testimony that the brave ATF agents are the ones showing up at 2 in the morning after a burglary.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've got a lot of criticism over this. So why is it not a machine gun?
In areas that are poor, mostly minority, there's a mass shooting.
Congress wants to change the law and come up with a new interpretation then ATF will follow that new interpretation.
A 2018 New Jersey legislation restricts the majority of gun owners to mags that contain up to 10 rounds of ammo. The law was affirmed by a lower court. A case that the justices remanded to a lower court involved a Hawaii statute that was comparable to the law in New York. The Second Amendment's protection to keep and bear arms in that case, according to a panel of 11 judges on the Ninth Circuit, does not guarantee any unrestricted general right to openly carry arms in public for individual self-defense. However, the Supreme Court ruled in its most recent firearms case that a person's right to carry a handgun for self-defense outside the home is protected by the Constitution. The Hawaii decision will now need to be reviewed by a lower court. The court also remanded a Maryland lawsuit that contested the state's 2013 ban on 45 different types of assault rifles for further study. A previous legal challenge to the law had been rejected by the Supreme Court in 2017. Similar action was taken by the Ninth Circuit over a firearms case that contested California's assault weapon ban. The case was sent back to the Los Angeles District Court by a Ninth Circuit 3-judge panel, allowing the lower court judge a chance to re-evaluate it in light of the new guidelines. The Ninth Circuit is currently hearing a San Diego assault weapon prohibition complaint, though the appellate court earlier decided it would be suspended pending the outcome of the Los Angeles case. Supreme Court asserts right to carry pistols in public. In a society that is bitterly divided over how to combat gun violence, the Supreme Court said for the first time that in the U.S. Constitution protects a person's right to carry a pistol in public for self-defense. The restrictions on carrying concealed handguns outside the home in New York State were overturned by a 6-3 decision, with the conservative justices in the majority and the liberal justices dissenting. The law, passed in 1913, was ruled to violate the Second Amendment's guarantee of the freedom to keep and bear arms by the court. The opinion, which was written by Justice Clarence Thomas, may overturn similar limitations in other states and jeopardize other kinds of municipal, state, and federal gun control measures countrywide. There are no other constitutional rights that a person can enjoy only after proving to government officials that they have a unique need, Thomas stated. In a country with high levels of firearms violence, including multiple mass layings, gun rights are a difficult topic. They were given by the country's founders in the 18th century and are dearly held by many Americans. Just recently, 10 people were slain on May 14th at a grocery store in Buffalo, New York, and 19 children and 2 instructors perished on May 24th at an elementary school in Uvalde, Texas. The decision was criticized by President Joe Biden, who has termed gun violence a national embarrassment. This decision should cause great concern for all of us, according to Biden, as it goes against both common sense and the Constitution. We as a society must do more, not less, to protect our fellow Americans in the wake of the horrific attacks in Buffalo and Uvalde, as well as the daily acts of gun violence that do not make national headlines. In dissent, liberal Justice Stephen Breyer said that the court had increased gun rights without considering the nature of severity of gun violence in a nation where there are more guns per person than any other. According to Breyer, the decision denies governments the authority to handle significant dangers. The Supreme Court reversed the decision by a lower court that had dismissed a legal challenge to the legislation brought by 2 gun owners and the New York chapter of the National Rifle Association, NRA, a powerful gun rights organization largely associated with Republicans.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Field background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
The court's conservative majority is inclined to expansive view of Second Amendment rights. It was the court's most significant declaration regarding gun rights in over a decade. In a case involving the District of Columbia, the court acknowledged an individual's right to keep guns at home for self-defense for the first time in 2008. In 2010, the court extended this recognition to the states. Democratic Governor Kathy Hochul of New York referred to the decision as absolutely shocking. Mayor of New York City Eric Adams stated that authorities will examine licensing procedures and how sensitive areas are identified, adding that we cannot allow New York to become the Wild West. According to New York law, applicants for unlimited concealed carry permits had to persuade a state licensing official of an actual necessity for self-defense as opposed to a hypothetical one. The majority of applicants were granted unrestricted licenses. With it compared to heavily populated New York City, these were granted more readily in rural areas. Licenses that are only valid for certain activities such as target practice or hunting may also be issued by officials. The decision made it clear how courts must now determine whether rules are legal under the Second Amendment, mandating that they be similar with limitations that have typically been established throughout American history. According to Thomas, the concealed weapon law in New York failed this criteria. Gun control advocates worried that the decision could undermine laws restricting for sale untraceable ghost guns built from online parts, expanded criminal background checks for gun buyers, and red flag laws that target the firearms of people deemed dangerous by the courts. They worried that it may compromise laws prohibiting guns in sensitive locations like schools, hospitals, and airports. The decision will directly impact at least 6 states, including the District of Columbia, New York, California, Hawaii, Maryland, Massachusetts, and New Jersey, which permits officials to decide whether a person is allowed to carry a concealed handgun in public, even if they meet certain requirements like passing criminal background checks. Rhode Island, Connecticut, and Delaware also grant officials some latitude. The decision allows states to ban firearms in sensitive places, potentially extending beyond the traditional examples of this category, such as courthouses and legislative buildings. Courts can use analogies to those historical regulations of sensitive locations, Thomas added, but Breyer questioned, so where does it leave the numerous areas in a contemporary metropolis without any evident analogs from the 18th or 19th centuries? What about the subways, bars, theaters, and sporting venues? The court is silent. Tom King, president of the New York State Rifle and Pistol Association, the state chapter of the National Rifle Association, NRA, told Reuters that he would like to see as few locations classified as sensitive as possible and that he would bring legal challenges if, for instance, authorities attempted to forbid firearms on subways or buses. In a concurring opinion, conservative Justice Brett Kavanaugh said states might still require fingerprints, background checks, mental health screenings, and firearms training sessions from applicants for permits to carry weapons. Conservative Justice Samuel Alito disagreed in a separate concurring opinion that stricter gun laws like those in New York would prevent tragedies like the Buffalo Massacre. It is clear that the New York legislation in question in this case did not deter the offender, Alito said. Supreme Court continues to challenge gun restriction following landmark ruling. Following the historic decision expanding individual gun rights, the U.S. Supreme Court overturned a number of lower court decisions that had upheld gun restrictions, including Maryland's ban on assault-style rifles, and New Jersey's and California's bans on large-capacity ammunition mags, in light of their decision on June 23rd declaring for the first time a constitutional right to carry a pistol in public for self-defense. The justices' decision remanded several cases to lower courts for reconsideration. New York State's restriction on carrying concealed firearms outside the home were overturned by a 6-3 decision, with the conservative justices in the majority and the liberal justices in dissent. The law, passed in 1913, was ruled to violate the Second Amendment's guarantee of the freedom to keep and bear arms by the court. The decision also made it clear how courts must now judge whether limits are legitimate under the Second Amendment of the United States Constitution, calling for them to be comparable with limitations that have typically been enacted throughout American history. Legal experts believe that if courts apply this criteria, additional gun laws across the country may be declared invalid, which worries gun control activists. Due to the justice's actions, lower courts that have upheld Maryland's ban on highly dangerous military-style assault rifles may have to revisit their rulings. After a slayer used one of these weapons to slay 20 children and 6 adults at Sandy Hook Elementary School in Newtown, Connecticut in 2012, Maryland adopted its prohibition. According to Maryland, 5 other states have similar laws against these firearms. The May 24 incident in Uvalde, Texas, which resulted in the ending of 19 children and 2 instructors at an elementary school, as well as the May 14 attack in Buffalo, New York, which resulted in the ending of 10 people, both included assault-style rifles, despite admitting that their case was lost as a result of a 2017 decision by the 4th U.S. Circuit Court of Appeals, which upheld Maryland's ban. The Maryland plaintiffs nonetheless filed their lawsuit in 2020. The appeal of the decision was not heard by the Supreme Court.
I don't have a gun, but I don't give a damn about anybody else having one.
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
What changed is that that item that was submitted was not produced and was not the item that was marketed.
The government quite properly charged him with several crimes.
Sensitive places doctrine was not at issue in this case and still exists.
But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way.
He went on to say he looks forward to a quick resolution in the Texas Senate.
Predictably, Mr. Rahimi soon thought, to hell with your restraining order.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
Aggravated assault with a deadly weapon against a different woman using a gun that he wasn't legally allowed to own, but obtained anyway.
The Maryland plaintiffs argued that the term assault weapon is a misleading political term, and that it cannot be outright banned because millions of law-abiding people use assault weapons, just like the handguns at issue in the 2008 Supreme Court decision that overturned the ban on firearms in the national capital. Other judgments maintaining the prohibitions on handgun mags containing more than 10 rounds of ammunition in New Jersey and California were ordered back to lower courts by the justices. State chapters of the National Rifle Association, a pro-gun rights organization closely associated with Republicans, brought the lawsuits in those cases. A lower court judgment upholding Hawaii's ban on openly carrying weapons in public as legal under the Second Amendment was likewise overturned by the Supreme Court. In a society with high rates of gun violence, gun rights, which are valued by many Americans and promised by the country's founders in the 18th century, are a difficult topic. The court's decision was its most significant declaration on gun rights in over a decade. In a case involving the District of Columbia, the court acknowledged an individual's right to keep guns at home for self-defense for the first time in 2008. In 2010, the court extended this recognition to the states. The first significant federal gun reform in 30 years was signed into law by President Joe Biden 2 days after the court struck down New York's gun regulation. The new law restricts for sale of firearms to people with domestic violence convictions and bans sales to people convicted of abusing unmarried intimate partners. Additionally, it gives states that enforce red flag legislation meant to take away firearms from those judged dangerous to themselves and other new federal cash. The policies that Biden favors do not prohibit the sales of assault-style rifles or large capacity mags. However, it does advance background checks by making it possible to access data on serious youth offenses for the first time. Supreme Court's Second Amendment ruling sparks division and uncertainty. A significant Second Amendment ruling by the U.S. Supreme Court has divided judges and created uncertainty about what handgun limitations can still be in effect across the nation. According to experts, the High Court decision that established new criteria for analyzing gun restrictions left many concerns unanswered, leading to an increase in the frequency of contradictory rulings as lower court judges struggled to implement it. The standard that lower courts had long used to judge arguments against handgun limitations was altered by the Supreme Court's so-called Bruin judgment. The justices said that judges should no longer take into account how well the law advances societal goals like improving public safety. According to the new standard established by the Supreme Court, the government that wants to uphold a gun restriction must demonstrate that it is consistent with the nation's historical tradition of firearm regulation. Federal rules intended to keep guns out of the hand of domestic abusers, felony defendants, and marijuana users have recently been ruled unlawful by courts. Judges have invalidated Texas gun control laws for young adults and the federal ban on owning firearms with their serial numbers deleted. They have also prevented Delaware's ban on the ownership of handmade ghost guns from coming into effect. Following the verdict by the conservative Supreme Court majority, judges have in a number of cases reached conflicting conclusions about the constitutionality of the same statutes. The Supreme Court will likely intervene once more soon to provide additional advice for judges due to the legal confusion generated by the first significant gun ruling in 10 years. According to Jacob Charles, a professor in Pepperdine University's law school who specializes in weapons law, there is confusion and disarray in the lower courts because they not only are not reaching the same conclusions, they're just applying different methods of applying Bruin's method differently. What it means is that not only are new laws being struck down, but also laws that have been in effect for over 60 years, 40 years in some cases, are being struck down. He added, before Bruin, courts were unanimous that those were constitutional. The legal wrangling is going on as the country, which is awash in weapons, continues to have mass layings, and as law enforcement officials all throughout the United States attempts to stem an increase in violent crime. Numerous horrific shootings have claimed the lives of dozens of people so far in 2023, including one in California, when 11 people were murdered as they celebrated the Lunar New Year at a club frequented by senior Asian Americans. According to the Gun Violence Archive, there were more than 600 mass layings in the United States last year, each of which resulted in at least 4 fatalities or injuries. The judgment allowed for a flurry of legal challenges from gun rights activists who saw a chance to overturn regulations on everything from age restrictions to semi-auto rifles in the AR-15 model. The Bruin judgment, which eliminated what proponents of gun rights view as unconstitutional restrictions on Second Amendment rights, was a positive development. Mark Oliva, a representative of the National Shooting Sports Foundation, stated, "It's a true reading of what the Constitution and the Bill of Rights teach us. It unquestionably gives the lower courts clarification on how the Constitution should be applied in terms of our fundamental rights." After a federal appeals court ruled that under the Supreme Court's new criteria, the government cannot prohibit people with domestic violence restraining orders from having guns, gun control organizations have expressed concern. Interpreting the Supreme Court's Second Amendment test sparks legal debates. The Fifth U.S. Circuit Court of Appeals, located in New Orleans, noted that the legislation embodies salutary policy goals meant to protect vulnerable people in our society. The justices, however, came to the conclusion that the government had not provided a precedent from early American history that was sufficiently analogous to the current law. According to Attorney General Merrick Garland, the government will ask for a second opinion on that choice. While criticizing the Supreme Court's historical test, proponents of gun control say they are still convinced that many of the limitations will stand up to legal challenges. For instance, judges have repeatedly supported the federal law prohibiting convicted felons from owning firearms since the ruling. The Supreme Court stated that situations involving unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Shira Feldman, legal counsel for Brady, the gun control organization, noted that the court made it clear that the right to bear arms only applies to law-abiding citizens. The Supreme Court's test has prompted debate over whether judges should spend their time studying the past and whether it is appropriate to evaluate current legislation in light of previous rules or lack thereof. We are not experts on the views of white, affluent, and male landowners regarding the regulation of firearms in 1791. However, we are now supposed to play historian in the name of constitutional adjudication, stated former President Barack Obama's appointed Mississippi U.S. District Judge Carlton Reeves.
That Bruin is a thing from which the public must be protected. This is simply not true.
So other families will not have the experience and the pain and trauma that they had to live through.
For too long, states like New York told millions of citizens that their right to armed self-defense ended the moment they left their homes.
She proves you can run for office ending gun violence in the South and you can win.
Lawful gun owners are not the driving force behind criminal gun violence, and this is particularly true of concealed carry permit holders.
AK-47 is an automatic Kalashnikov model of 1947.
At the same time, as I outline in much greater detail in my written submission, they play a significant but underappreciated role.
You can prevent the next tragedy. You can save life. You can save families in the process.
Judges are really parsing the history very closely and saying these laws aren't analogous because the historical law worked in a slightly different fashion than the modern law, according to Andrew Willinger, executive producer of the Duke Center for Firearms Law. Others, he claimed, have engaged in a much more open-minded investigation and are attempting to say, look, what is the purpose of this historical law as best as I can understand it? Many pending lawsuits, including a few that challenge state laws outlawing specific semi-auto rifles and high-capacity mags, are being keenly watched by gun rights and gun control organizations. Using the new standard established by the Supreme Court, a federal court in Chicago rejected the request to halt an Illinois law that prohibits the sale of so-called assault weapons and high-capacity mags. But due to a different legal challenge, a state court has already partially invalidated the rule, enabling certain gun dealers to keep selling the firearms. Some of the gun prohibitions that were enacted in the wake of the Supreme Court ruling have already been overturned. A judge ruled that certain provisions of New York's new gun law, including those that prohibit carrying weapons in public parks and houses of worship, are unconstitutional. Later, an appeals court suspended that decision while it deliberated the matter. And for the time being, the Supreme Court has permitted New York to implement the statute. While some judges have ruled it illegal, others have upheld a provision that prohibits those who have been charged with felonies from purchasing firearms. A federal judge issued an order prohibiting Delaware from enforcing clauses of a new law regulating the production and possession of so-called ghost guns, which lack serial numbers and are frequently difficult for law enforcement personnel to locate. However, a different judge dismissed the challenge to the ghost gun laws of California. George Wu, a U.S. district judge who was appointed by President George W. Bush, appeared to poke fun at other judges' interpretations of the Supreme Court's instructions in the California case. The company that filed the lawsuit, and apparently certain other courts, want to treat the Supreme Court's ruling as a word salad, choosing an ingredient from one side of the plate and an entirely separate ingredient from the other, until there is nothing left whatsoever other than an entirely bulletproof and unrestrained Second Amendment, Wu wrote in his decision. Supreme Court considers Second Amendment case with implication for PLCAA protections. A fascinating Second Amendment matter was brought before the 8th Judicial District Court for the state of Nevada by KCI, and the Supreme Court is currently considering it. The publisher of Guns Mags, KCI, is currently the subject of legal proceedings since one of its mags was used in the commission of a crime. The primary issue is whether or not KCI can be held liable for criminal activity carried out by third party in accordance with the Protection of Lawful Commerce in Arms Act, PLCAA. The outcome of this case may have an impact on the PLCAA's protection against baseless claims, which would have significant effects on all businesses engaged in the manufacturing of weapons. There are worries that the current government wants to weaken these protections based on its objectives. It's really interesting to think about the circumstances that gave rise to this case. Along with being a supplier of books related to firearms, KCI is also in the business of publishing, importing, and distributing mags. A shooting that included one of KCI's mags on August 4th, 2019 served as the impetus for the investigation. The slayer acquired the mag through a third party who had originally bought it from a vendor who had the required legal license. You should be aware that KCI was not the main source for the aforementioned mag. The individual who gave the slayer the mag in the first place was found to have been illegally in possession of a firearm, as well as having lied about firearms. According to additional research, KCI's response was to submit a request to dismiss the case, in which they claimed that their mag satisfies the criteria for being regarded as a component part of a firearm and, as such, deserves to be granted protections and immunities under the PLCAA, a piece of federal legislation created to shield businesses connected to the firearms industry. However, after evaluating the matter, the court determined that the KCI-produced mag did not satisfy the criteria for being regarded as a component part of a firearm and, as a result, did not meet the requirement to be eligible for the protections and immunities given by the PLCAA. As a direct result of this, the court denied KCI's request to dismiss the complaint. The situation demonstrates the intricate connection between the Second Amendment, free speech, and the legal rights of organizations who deal with guns and ammunitions. The Supreme Court's decision will have significant effects on both the firearms industry and its interactions with the PLCAA. KCI said that the lower court erred by rejecting their application in a writ of mandamus filed with the Nevada Supreme Court. KCI contended that a firearms mag should be protected under the Protection of Lawful Commerce in Arms Act, PLCAA, as a component element of a firearm. A weapon mag does not meet the criteria to be considered a component part that should be given the safeguard provided by the PLCAA. According to the lower court, which reached a different decision, the lower court's reasoning may lead to major legal conflict, hence the corporation is appealing this ruling. In its petition to the Supreme Court, KCL underlined that Congress has mostly abstained from enacting comprehensive gun control laws, especially with regard to rifles and high-capacity mags. As a result, interested parties are turning to the judicial branch to achieve their legislative objectives. The Protection of Lawful Commerce in Arms Act, PLCAA, was intended to prevent similar litigation. According to KCI, using this legal strategy is an erroneous use of the court system.
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
To be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
KCI argues that the Supreme Court ought to intervene and rule in their favor because it's possible that the expansion of civil liability would go beyond what the Constitution's framers had in mind. They contend that situations like the one being considered require the extensive immunity provided by the PLCAA to be upheld. Despite the case being at the interlocutory stage, they contend that allowing the lower court to continue the case goes against the PLCAA's main objective. The lower court rejected the claim that litigation immunity exists specifically to prevent protracted trials and discovery, which is in line with the objectives of those who oppose the possessions of firearms. The PLCA's main goal is to dismiss claims before they develop into protracted trials or involve expensive discovery processes. On September 26, one of the first weeks of the Supreme Court's resumption for the following term, the matter is currently scheduled to be allocated for conference before the Supreme Court. Restrictions on large capacity mags. California Penal Code 32310 PC prohibits the possession, sale, manufacture, or importation of large capacity mags to reduce gun violence. The law aims to restrict access to ammunition feeding devices capable of holding more than 10 rounds. Any person in California who manufactures, causes to be manufactured, imports into the state, keeps for sales, offers or exposes for sale, or gives, lends, buys, or receives any large capacity mags is punishable by imprisonment. Manufacturing includes fabricating a mag and assembling it from a combination of parts. Possession of a large capacity mag is punishable by a fine. The law has faced numerous legal challenges since its introduction in 2000. In 2021, the U.S. Court of Appeals for the Ninth Circuit affirmed that California could constitutionally prohibit the possession and sale of large-capacity mags. However, the U.S. Supreme Court recently vacated that ruling and asked the Ninth Circuit to revisit the law based on recent Supreme Court decisions on other firearm cases. The critical elements of Penal Code 32310 criminalize two activities: manufacturing, sale of large-capacity mags, and possession of large-capacity mags. Manufacturing refers to fabricating the mag or assembling it from a combination of existing parts, while possession refers to having a large-capacity mag in one's personal control. Penalties for violating PC 32310 depends on the nature of the offense, whether you were accused of manufacturing, selling, importing large-capacity mags, or simple possession. Manufacturing, selling violations are wobbler offenses, while simple possession of a large-capacity mag is a wobblet offense under PC 32310. Defenses for large-capacity mags include unlawful search and seizure, lack of knowledge, or exempt status. That's all for this video, folks. See you next time.